we may have to redact some things in the Texas Code of Criminal Procedure when we're dealing
Yes.
with pro se defendants and offense reports under 3914.
Do you want to take a second to do that? And then when you're ready, let me know, and then we can have one of you guys accompany Mr. Emitom to the room back there and take as long as he needs.
Sure.
Is that okay?
Judge.
And then when he's done, we'll put everything on the record of all that he's looked at, all that he's seen, all that he's given access to. That way the record's complete with everything. So there's no issues anywhere.
Sure.
Is that okay, Mr. Emitom? Okay, so they're gonna have to redact some stuff, so just give me a second, just kind of hang tight. If there's anything you want to file, feel free to do it now.
I did at the clerk's office already, motion to suppress evidence.
Okay? You can also do it here.
Okay.
So next time, bring your stuff over here. We can accept it here. That way you don't have to make multiple trips here and there, because I know you live out of town, right?
Yeah.
It's silly for you to have to come in multiple times. Just come in at one time, file your stuff here. That way you don't have to make multiple trips, and then we can take a look at it as we go. Okay? So just hang tight. When they're ready, they'll let me know, and then we'll put you guys in the room.
Right, Judge.
Right. Oh, for the video?
Yeah, that's gonna mean that would take a while, right?
Well, we need a couple days to review it, figure out timestamps, and then send it over to our IT guys. So probably at least a week, probably two. But I mean, he's welcome to call the office since he's pro se judge, and we can coordinate a time.
Yes.
Possible.
Okay, so they have a body cam that's available. Or hold on a second, let's get this on the record, just so we're. Ramona, will you let me know when you're ready?
Hold on, Judge. Okay, Judge, I'm ready.
You ready?
Yes, sir.
All right. Guys, we're going on the record. Please keep it down. Today's date is October 14th. It's approximately 9:44 in the morning. I have in front of me. Mr. Eaton Emitom, cause number 2522688. Will the parties please identify themselves for purposes of the record?
George Lindsay for the state of Texas, bar number 240-99050.
It's on number five.
Okay, so I've said today's date, and we were here previously, I would say probably about a month ago, where Mr. Emitom has stated that he wants to represent himself. We went through a full thread of hearing, and I think that he's, I don't know whether he's qualified or not, but if he wants to represent himself, who am I to step in his way? And I'm going to let him represent himself. I've also today offered him counsel and told him that if he wants court-appointed counsel, I'm happy to provide it to him at no charge. Would you like counsel, Mr. Emitom?
No.
So you still want to represent yourself?
Yes, I still want to do pro se.
Okay. So at this point in the game, I think the state is still requesting and has outstanding discovery. They have in their possession now 2 articles. Mr. Lindsay, would you like to?
Yes, I would, Judge. The state was given notice this morning that the defendant had arrived to review discovery. The state has in its possession an offense report. The offense report number by Houston Police Department 1103179-24. Within that offense report contains personal identifying information of the complainant in this case, of which is the main complainant as identified on a felony charging instrument against the defendant in conjunction with this case. Under 3914, under Texas Code of Criminal Procedure, outlines certain procedures to release discovery to a pro se defendant. The state is in the process of reviewing said offense report, Your Honor. Is making the necessary redactions and we'll be able to have him review that document today. There is also a body cam associated with this case that was on the day of. The state, however, does need time to review that camera and that video in order to make any necessary redactions as is required under the state, under 3914 in the Texas Code of Criminal Procedure, and ask the court leave in order to do so. Since the defendant is pro se, I do not anticipate there being an issue with us coordinating with him in order to make an appointment to review that. It does have to do with his felony case, so the state would then, in the matter of judicial economy, ask that we could coordinate with the felony, so that way the defendant could come present a day. Understandably, he has to commute to present himself here at the office, not necessarily in docket. We can set up a room, and then he can review the evidence both on his felony and misdemeanor cases thoroughly, and that way to be more economical with the defendant's time and with the state and the court's time.
I think it's a great idea. So what he's saying essentially is he's going to coordinate with the felony court. That way the evidence can be at one time, all redacted at one time. So when you go up there to review everything, you don't have to come back and forth and back and forth. So they're going to coordinate with the felony court. So it all happens at one time. Yeah, of course.
The motion to suppress evidence from, I don't know if that's what I filed today, just to look at this, suppress some of the evidence because I had some arguments in that. And I also have the witness with me that wants to file the affidavit that was claiming the legal hemp that was in the vehicle. So they also want to file, I know that was on video. I had my own video that was recorded from the witness that was recording that day too, but I haven't submitted. That was just my evidence that I had. So I'm still waiting for the body cam as well.
I have looked with our clerks. We don't see the motion to suppress.
I have a copy, right? I just did it today.
Oh, you filed it
Yeah, that's
today.
fine.
Oh, I see. Okay.
For the purposes of the record, Judge, the state has not been given any motion.
Right. And we don't have it either because since he just filed it, it's going to take a couple days to work it through for them to make copies. And then they upload it to what's called deeds, which is the database where we get to look at all motions that have been filed. It takes at least 2 to 3 days just to work it through all to get onto deeds for us to even look at it. Typically, when you give something, you have to provide it to all parties at the same time. So you also have to provide it to the state as well. Okay.
I could right here if they need it, or if they need to make it.
We can, yeah, we'll do that for you if you like. First file it and then we can make a copy. Whoever you want to file anything as well, or whoever's here that wants to file it, they're welcome to file anything over here. We can make copies and provide it to the state as well. As far as the motion to suppress is concerned, we don't do it just on a day here or a day there. We carry it with trial. So what we'd essentially do is we would pick a jury, and then we hear all motions at that time. After we do jury selection, we would kind of break, send them for lunch, and then we do all motions at that time. So we don't do it, motion to suppress here and then go to trial there. It is all done at one time for judicial economy as well. That way we're not going back and forth, right? Because what happens is if I deny your motion to suppress here, you're going to want to have to, sometimes you want to redo it again in trial. So I don't want to just double up like that. So that's why we do it all at one time. So we're not going to do any motion to suppress. You can file everything now if you'd like, but we will carry it with trial. And it's going to take a while to get to trial because I don't even know what other evidence is outstanding, but because you have a felony case as well, it's going to take a while for you to get through and look at all the evidence. So what I would say is within maybe like 3-4 weeks, call and make an appointment with them, and I can get them to give you their main direct line. And that way you can call, set up an appointment, and then you can come up to their office. They'll give you a particular room and you can sit and review all the evidence at one time. It's going to take them a while, so you be patient because remember, you also have a case upstairs, so they're going to have to coordinate with them, get all the evidence for everything at one time, and have someone redact it.
I need to bring a CD or a USB or anything to get the
I'm
file.
not good. I don't think that they're going to let you copy it. You bring your own device to look at everything, and then you can take, take a legal pad to take notes, but I don't think that they're going to give you a copy of it.
So I could get that type of evidence to help represent myself in the case.
You can view it, just view it, right? You don't give
Officer's complaint or anything, the complaint.
anything that's a public record that's in deeds, you can. So you can always go through the district clerk's website and, put in your name. They'll have a list of documents there. You can always, make copies and have those documents, but a lot of the stuff that they have in their files, you can't just take and keep it for yourself. It has a lot of sensitive information. And because of that, they don't want to just give it up. And then they don't want you to disseminate it out elsewhere. And so it could be very problematic. So as a result, you go to the office, go to their office, take a couple hours, as much as you want. You can go 5 times if you want. You can go 6 times, as many times as you want. You can go and look at the evidence. I don't think they're going to give you a copy to take home.
That's the case indicted yet? Has it been indicted yet?
Your Honor, the misdemeanor, there is no indictment charged by misdemeanor information under the Texas Code of Criminal Procedure. There is a felony indictment that's already been returned by a grand jury for felony.
So it has been indicted in the felony case. When was it indicted? You
The felony was indicted September 16th, 2024, Your Honor.
You should be able to go to the district clerk's website, put in your identifiers and pull up all the information that you have there so that you can get a good idea of what's out there.
And also, Your Honor, the district clerk is located on the 3rd floor of this building in case he doesn't have computer access. He wants to go in person.
Well, he's got one, and I think that he's actually been there as well to file documents. Anything else you'd like to add? Okay. Do you want to set off a month, 5 weeks?
A month will be fine, Judge. He'll give us some time to take a look at the body camera and make the redactions that we necessarily need to make. And then hopefully we can coordinate an appointment before we return to court. That would be the state's position. So hopefully we can get all the discovery reviewed before our next setting. So maybe even
That's
5
enough time
weeks.
for everything, right?
Yes, sir. That would be our intent. I think the felony has a setting currently of October 22nd.
Next week.
So next week. So I'll contact the felony prosecutor up there and kind of see what their schedule allows for. If we could set off 5 weeks, I guess, Judge. I mean, whatever the court
So
deems appropriate.
what day 5 weeks from today is good for Victoria?
So November 18th through the 21st.
What day would you like? November 18th through the 21st.
18th, right?
Well, hold on, let's see. So November 18th is a Monday.
That's fine.
You want that Monday?
Wednesday?
You want, the Wednesday is the 20th. You want the Wednesday?
Yeah.
Okay, so November 20th is our next setting here. And then I would say wait at least 3 to 4. This is a 5-week setting to give them enough time to get everything done so that you can look at everything before our next setting here. So I would say 3.5 weeks to 4 weeks out, probably. I would make an appointment for the week of like November 11th to look at everything that they have. And hopefully they'll have everything done. You should be able to have everything, right? You think
I would
so?
hope, Judge.
What if I
You
don't
never
have
know
it?
what's gonna happen in 4 weeks, right?
If I don't get to see the videos by the next hearing, or if it's a way I
You
don't.
will get as much time as you need. I'm never gonna rush you. I will never do anything to hinder any kind of, anything for you. If they don't have it ready, I can give you more time. There will never be an issue with time, right? You're gonna have a lot of time upstairs as well. So don't worry about the time. It's a matter of trying to make it so you don't have to keep coming back and forth and back and forth. And perhaps when you go up with your felony court next time up there, ask them for this same date here, that we don't have to piecemeal for the felony misdemeanor as well.
Witness, what should they file their affidavit? Do they just need to do that with the clerk downstairs, or?
Yeah, I mean, they've done it properly?
I just got them here with me, so today, so. they're
File
trying
with
to
the clerk, Judge. Clerk can
Yeah.
swear them in on their document and they can turn it
Yeah,
in.
okay, bring them here. They can swear to anything here.
And just bringing them paperwork.
Swear them here. Anything else?
Not from the state, Judge.
Chairman Tom, anything? Okay, so we'll see you here November 20th. Make sure you make an appointment, try probably like 4 weeks, week of the 11th, and then good luck. Okay, all right,
Someone look at the office report.
off the record.
Judge, are we still pending discussion?
Yeah, pending discovery, yeah.